Thank you, Christopher. Good afternoon or good morning, everybody. Welcome to the second session in the Abuse in Later Life webinar series for civil attorneys and legal advocates. We are really happy that you are here today. This series is made possible by a grant from the Office on Violence Against Women, U.S. Department of Justice. And the opinions, findings, conclusions, and recommendations that you're going to hear from the presenters today are ours and do not necessarily reflect the views of the Office on Violence Against Women. The National Clearinghouse on Abuse in Later Life, who co-sponsors this webinar with the ABA Commission on Domestic and Sexual Violence, is the comprehensive technical assistance provider for the OVW Abuse in Later Life Grant Program. Since 1999, we have been the only national organization that provides technical assistance, training, and consultation on the intersection of domestic violence, sexual assault, and elder abuse. We are a national project, and we have 5 staff members. And I will turn it over to Jane to talk about the ABA Commission.
Thank you, Anne, and thank you to Christopher for your support today. Welcome, everyone. The ABA Commission on Domestic and Sexual Violence provides free training and technical assistance to attorneys representing survivors in civil legal proceedings. We can help with case-specific questions. We have a number of publications, and we also host 6 listservs, including our popular Litigate listserv, which provides a forum for victims' attorneys to discuss issues that arise in the process of litigation and to provide peer-to-peer assistance and mentorship. We also have listservs for managers, supervising lawyers who represent survivors, a listserv for LGBTQ+ case practitioners, and a listserv for law school faculty who teach classes and clinics around gender-based violence, as well as a friends listserv for anyone who's interested in our work and would like to keep in touch with us. So I'm going to drop the link to the listservs into the chat. We hope you'll take a minute to check out our website and reach out to us for training and technical assistance. Our website is ambar.org/CDSV, and I just dropped that into the chat as well.
Thanks, Jane. This kind of gives you an idea of where we are at in the journey that is this webinar series. So last 2 weeks ago, we talked about just kind of an overview of abuse in later life dynamics, some challenges that survivors have in seeking support and healing services. Today, we're going to talk about forming the relationship with your client. What's the best way to do that? What are some victim-centered ways to do that, to build trust and build the relationship and start working on their goals. So we hope that you'll be able to join us for the whole series. Just one quick note, the sessions are all 2 weeks apart with the exception of modules 4 and 5. Those are only a week apart because we wanted to avoid the holiday. So again, I thank you for being here.
I will go over the overall webinar series objectives. So the learning objectives for the series are participants will be better able to identify and describe key dynamics of abuse in later life, effectively recognize and respond to cases of abuse in later life, access client-centered community-based resources, and provide effective client-centered information advocacy to abuse in later life clients. Okay, today, we will be focusing on forming the relationship with your client. And the learning objectives for today's session are participants will be able to, 1, use a victim-centered approach to identifying clients experiencing abuse in later life and navigating challenges to client communication, describe boundaries of privilege and confidentiality and potential challenges presented by mandated reporting, and develop a victim-centered advocacy and lawyering approach to representing clients who are experiencing abuse in later life. I will briefly introduce myself. My name is Jane Zai. I use she and her pronouns. I am the managing attorney with the ABA Commission on Domestic and Sexual Violence. I've been with the ABA for the last 7.5 years. Prior to joining the team at the ABA, I was a legal services attorney working in Chicago and in Albuquerque, New Mexico. I've represented a wide variety of clients in primarily order of protection cases, including older clients and cases with adult protective services overlap and involvement. And I am very happy to be presenting today with Anne, who will now introduce herself.
Thank you, Jane. My name is Ann Lotch. I am the Justice System Coordinator for the National Clearinghouse on Abuse in Later Life. I'm totally going to cough. Excuse me. We provide training and technical assistance on justice system responses. Oh my God. When I put cracked red pepper on my sandwich today, I had a feeling I shouldn't do that. Before joining NCALL, I was a legal services attorney here in Milwaukee, and I provided representation to older victims of crime and do a lot of trainings on a range of topics, typically related to elder abuse and the justice system's responses to elder abuse. So I'm very happy to be here with you guys today. Oops. So I think everybody is muted. We would like you guys to stay muted if you don't mind. And we are going to have a lot of interaction and some Q&A. So it would be really great to hear from you. It's always good for you guys to be able to learn from each other as well as from the content that we are presenting. We will be keeping an eye on the chat. So if you have questions or concerns or you want to participate in any way, please just drop those in the chat and we'll be keeping an eye on that.
Okay, let's get started. And thank you again, everyone, for being here today and for your participation in today's module. I want to start by offering a foundational concept that is critical for all the work that we do serving clients and survivors, and that is to approach client services with a trauma-informed, victim-centered lens. We want, when working with clients, to recognize and acknowledge their knowledge and expertise, their decision-making abilities, and recognize our clients as a member of the team working alongside you to achieve their legal and non-legal goals. And this applies to all the clients that we work with. This slide was created by the Confidentiality Institute. It reminds us of the core values at the heart of victim-centered advocacy and lawyering. That is to listen without judgment, offer alternatives and resources, and defer to the survivor's decisions. So part of victim-centered advocacy is giving clients the tools and the knowledge they need to make educated decisions about the things that are affecting their lives and their cases. When we talk with our clients, we need to ask them what they consider to be the most important issues that they want to address and what they are hoping to achieve in both the short term and the long term. So what they ultimately want, it might be achievable through non-legal methods. And what our clients deem as success may not be what us as practitioners see as success. As such, it is important to listen without judgment and then offer different solutions, resources, and paths that the client may take. And then ultimately, it is the client's decision as to how to proceed. Again, the client is the expert on their own lives and what will keep them safe, and they know best what they are hoping to accomplish. It is important to defer to the client with the decisions they make because their lives will continue after the court case has concluded, And also we want to empower clients and give back some of the power that they may have lost. These values are at the heart of the entire webinar series and provide guiding principles for all of the webinar modules. And I will pass it back over to Anne.
Thanks, Jane. So we're going to just talk a little bit about identifying abuse in later life in the first place. You may have already worked with survivors of domestic violence or sexual assault. And like them, clients who are dealing with abuse in later life might be reluctant to disclose that abuse to you, especially the first time you're meeting them. But because the very fact that that abuse is going on can have a profound impact on your representation of that client and everything that you do together. So, and that includes your professional legal obligations and ethical obligations to that client. So we're going to just quickly review some of the common indicators of abuse in later life. But first, actually, I'm going to skip that, good thing, because we didn't set that up. So I want to talk first about some of the risk factors. I know we covered this last time, but some people might not be able to, or might not have been able to join us. Abuse in later life can and definitely does happen to older adults of all ages. 50 and above is what we consider abuse in later life. All genders, all racial and ethnic backgrounds, all identities, all economic statuses. But there are some categories where abuse, the risk of abuse is a little bit elevated. One of those is gender. And so when we've examined cases and looked at cases where the person's gender has been reported, 67% of victims identified as female and 33% identified as male. The other risk factor that is known to really increase somebody, or the other factor that really increases somebody's risk, is isolation, social isolation. There's been, especially in recent years, I feel like there's been a lot more talk about the importance of that when it comes to all around health. The same goes for safety and protection. During the pandemic, as I'm sure we're all aware, that we saw a frightening confluence of factors that was an increase in isolation and a decrease in elder abuse reporting. I think because people, at the beginning of the pandemic, there were so many questions, and people were so isolated and locked down that it was our fear that there was a lot more opportunity for abuse. So long-winded way of saying isolation and gender are huge risk factors for abuse. A couple others. If the older adult is in poor physical health and may be dependent on somebody else for care, there can be an additional risk for abuse, or if they have dementia or mental health issues. There are numerous studies around the link between dementia and abuse in later life, and they have different conclusions, but they were both really grim, and that is that between 1/3 and 2/3 of all older adults who have dementia had experienced some form of abuse. There are also risk factors on the perpetrator's side that can increase the likelihood of somebody who's acting in an abusive manner towards an older adult. One of those is whether the perpetrator has substance abuse factors or mental health issues that are impacting their behavior. Another factor that sort of elevates somebody's risk of committing abuse is having a prior history of abuse with an older adult. There are also risk factors for perpetration of elder abuse that may increase the risk of a caretaker acting in an abusive manner towards an older adult. So if somebody themselves has been victimized in the past, there are studies that show they have a slightly higher risk of committing abuse themselves. And then victims of, this is on the victim side again. Victims of one form of elder abuse are at the highest risk for other co-occurring forms of abuse. And victims of elder abuse are more likely to have suffered other forms of abuse in the past throughout their lifetime. And I'll turn that back over to Jane.
Thank you. Although the dynamics of power and control may differ across individuals, cultural groups, and how it's perpetrated against or impacts members of marginalized communities, there are some things that you as a practitioner can look out for when you are working with clients as indicators of abuse in later life. These indicators may not appear with every client, and as we have probably all experienced, sometimes abusers act in a way that is opposite of what you would expect. Practitioners can use the following as indicators of abuse in later life. One, if a person accompanies the older client to your office and that person does not want you to speak privately with the older client, that should raise some red flags for you. Two, if another individual, be it a caretaker, family member, partner, or spouse, is verbally aggressive or demeaning or controlling of the older person. If the older client may request financial arrangements that appear to be disproportionately benefiting the caregiver or others at the expense of the older client. And four, in the materials, I will drop the link into the chat again to the resources and materials for today's module. There is an abuse in later life power and control wheel where you can find some additional indicators of abuse in later life listed. Some examples from the abuse in later life power and control wheel include denies access to spiritual traditions or events, uses privilege, and isolates. So you can take a look at that wheel to get a sense of some other indicators that might show up when you are meeting with clients and they are describing their experiences, or you could see it yourself with an individual who may be accompanying your client. We are now going to move on to forming the relationship with your client and some considerations for intake and the initial interview with your client. When we refer to general screening questions here, we are talking about questions that you as an attorney might be asking the client during their first office visit. So please note that clients might react differently to these screening questions, and some people might feel offended by a certain question or confused. So it is important to explain why you are asking these questions and that you ask everyone these questions during the screening process. So first, you should ask what legal services they are seeking, such as drafting a will or obtaining an order of protection, and whether that legal matter involves other people as well. This is important to ask so that you get a full picture of what the client's needs are and whether their safety might be implicated depending on the other people involved with the case, and to assess whether there might be some coercion or control happening. Is this something that the client wants, or is this something that someone else is asking the client to do, for example? During the initial interview, you should ask a standard set of questions to assess safety, such as, is the individual here with you today? Do you feel safe in your home? And has anyone close to you tried to hurt or harm you recently? Have you relied on people for any of the following: bathing, dressing, shopping, banking, or meals? And has anyone prevented you from getting food, clothes, medication, glasses, hearing aids, or medical care, or from being with the people that you wanted to be with? Have you been upset because someone talked to you in a way that made you feel ashamed or threatened? Has anyone tried to force you to sign papers or to use your money against your will? Has anyone made you afraid, touched you in ways that you did not want, or hurt you physically? And all of these slides are also in the resources folder that we've been sharing in the chat. These are all questions that you can ask to assess what is happening and what type of abuse or coercive control might be taking place. But these may also be very difficult questions for your client to answer. They might feel ashamed, they might be scared, or they might not yet have trust in you as a service provider and not understand how you may be able to use this information to help them. Clients may not feel comfortable disclosing this information right away. They might feel more comfortable later when the attorney-client relationship is more well established. Later, Anne will be going through some other barriers to disclosure, but it's important to remember to respect the client's comfort and to take the interview at the client's pace and give the client as much control and decision-making power during your interviews with them as you can. Let them know that they can take a break whenever they need, that they do not have to talk about something they are not comfortable speaking about at that time. You should make note of any areas requiring follow-up questions, either later in the interview or during a follow-up meeting. And additionally, during the course of legal representation, new or additional incidents of abuse might arise. So it's imperative to continue asking follow-up questions as cases evolve.
Great. Thanks, Jane. There is one question in the chat. When asking, do you feel safe in your home? Should you be distinguishing between physical safety and emotional safety? I think keeping it, Jane, let me know if you have a different perspective, but I think keeping it just that general, let them interpret it the way that they want. If there's any way in which they feel unsafe, it would be great if they felt comfortable disclosing that to you. Thank you for that question. And just a reminder, we are both keeping an eye on the chat. So if you do have questions as we go along, we will try to get to those as soon as we see them. So please feel free to drop those in the chat. So ideally, if you're starting a relationship with a client and you're building trust with them, they're going to feel comfortable disclosing to you if something is going on, especially if that's going to impact your work with them. But again, it's a hard thing to talk to somebody about, even when it's someone you know. So when it's someone you've just met, they may be disclosing to you in a way that is more subtle and is sort of talking around the issue. That is something we call coded disclosure. And when that happens, they may want you to know about the challenges that they're facing, but they may have fear for their own physical safety. They may worry about maintaining access to care, to their resources, to their home. They may, for lots of reasons, they may be hesitant to just say that with you directly. So coded disclosure can be a safe way for them to raise the topic with you, especially early on in your relationship, where you might have to pick up on it, and it might be subtle, but they're really trying to tell you that there's something else going on. So some things you might hear are, oh, I don't want to make anybody mad, or I just do what my husband says. He gets a little rough with me sometimes, or she doesn't think I do anything right. She gets really frustrated with me. All those kinds of things are cues for you to maybe explore a little bit more and see what is going on there. If any of you have had a client use coded disclosure to make you aware of their situation, I would love to hear about that. You could drop that in the chat, but just something to know about, that it exists, and to kind of train yourself to be listening for, because you're listening for what they're saying, but also to what they're not saying, right? All right. So let's talk about some barriers to disclosure that have to do with accessibility. We know that when we talk about older adults, the majority of older adults are in good health and function just fine. But there is an increasing risk of disability as we age. It's just a fact of life. So some survivors of elder abuse may face additional barriers to disclosing if they do have accessibility concerns. We are going to see the first 3 minutes of a video called Roma. Roma is an actual survivor, and she lives with a disability. And this video kind of shows some of the barriers to having the criminal justice system address a situation where she was being abused, but she is not physically able to speak. And I love this video because it really illustrates a successful collaboration between Roma, her prosecutor, who's in the video, who helped to, and shows how she helped to get a successful conviction for Roma's abuser. So please note that this, the material that is discussed here can be upsetting and may be triggering for you. So it's about 3 minutes long. Let's take a look.
When I first met Roma, I was introduced to her by the detective who investigated Roma's case, Detective Tina Knightley. And Detective Knightley helped me to be able to understand how Roma and I could communicate. And from that first meeting, Roma and I met 2 or 3 times a week over a period of, I would say, 4 or 5 months. And we used, initially at least, very extensively, used this loose leaf binder, which has pages. And the page that we used the most was a page with the alphabet. And Roma points to the letters of the words. And after we met more regularly, I was able to understand what word Roma wanted to say just through even the first letter. And I was also able to, over the course of time, understand what Roma was saying without the letters. Because we became familiar with each other, and that was critically important in terms of being able to work together in the courtroom, as well as being able to talk about things, issues, and talk about the details of the case. The book also includes pages with common phrases so that Roma doesn't have to spell those out, and pictures. So this really is the primary tool by which Roma communicates with the world. And Roma and I worked together on a case that involved her, in which she was the victim of a rape and an indecent assault and battery. Roma was sexually assaulted by her personal care attendant. That personal care attendant was an individual who took care of Roma overnight. And the assault occurred in the course of shaving Roma's legs. Roma attempted to tell someone about what had happened to her as soon as the personal care attendant was off duty. Roma, called another personal care attendant, but that individual was unable to understand what Roma was saying to her. So Roma had to wait until 2 personal care attendants who were able to understand her came.
So you can see, we've talked in the last module about how one reason that older people and some younger people don't disclose abuse is that they're afraid of not being believed. So imagine having that compounded by disclosing to people who are not putting in the effort to listen to you and to understand what you are saying, and who just are disregarding it because they are not able to understand you. So it's such a good example of somebody meaning the prosecutor, who took the time to understand how Roma communicated and to meet her at that level and to make sure the video is much longer. And there's a whole segment on the court process and the accommodations that were made and how she was able to tell her story. And I think it's just a good reminder for all of us. So there are some other groups of folks who might also face some additional barriers in reporting elder abuse, and that is people who are members of traditionally, historically marginalized communities. This is obviously a greatly abbreviated list of some of the barriers that people, members of marginalized communities might face when disclosing abuse in later life. But it's important to bear these common barriers in mind when you're working with abuse in later life clients, because first of all, you have no way of knowing initially whether your client is a member of a marginalized community, right? And second, those concerns might be of even greater importance to your client than achieving whatever it is you think you'll be doing with them related to the criminal justice system. So again, this is getting back to principles of victim-centered advocacy. And we're also talking a little bit about intersectionality here, because a lot of folks are going to fit into, one or more or all of these groups. So just like coded disclosure, it's something you want to have in the back of your mind and realize that anybody you're speaking with might fall into one of these categories, and that could be giving them some additional hesitation in disclosing that abuse to them. Maybe in the past, they have not had good experiences with agencies that are supposedly there to help them. Maybe there are cultural differences in the way that they grew up in their community and the way that abuse is approached in that community versus in the community that they're assuming you represent. Maybe they have concerns about immigration. Maybe they want to disclose abuse, but they are undocumented and they're afraid that if they do, they will be deported. They may have privacy concerns, especially when it relates to things that are typically handled within the family. If they're from an environment where you don't talk about family business outside of the family, it could be really difficult for them to make that decision to speak with you. So just keep in mind that they could be having these issues and that we don't have any way of knowing whether or not they are from a marginalized community or not. So we should just be aware that these may be factors that are at play in their situation. So when somebody does disclose and is comfortable talking to you that abuse in later life is going on, what do you do? So there are resources out there. We're going to talk a lot when we talk about collaboration. We're going to talk about, oh, these slides are flipped. I'm going to make a note of that. So I'm going to go to the next one. What are some things that you can do? How do you respond? And if you haven't thought about this, it may be surprising, and it may be you maybe feel like you're scrambling when somebody does disclose abuse to you. So it really is good to kind of have a plan. Like if somebody lets me know that this is going on, what am I going to do? How am I going to respond? What am I going to offer? How am I going to non-judgmentally support this person in a victim-centered way? So the first thing you can do is to listen without judgment. Just hear them. And oftentimes that is, you may be dealing with somebody who has never just had somebody sit and listen to them. That can be the most valuable thing that you can do, is be affirming and listening. Believe that your client is accurately describing their experience to you. I feel like I say it in every single training that we do, but even first of all, not all older people have dementia. We've established that, but our risk of dementia does increase as we age. However, there are studies that show that even somebody who has advanced dementia can accurately reflect and describe events that have happened to them. So you might get that story in bits and pieces, and it may be a little bit out of order. But as I said, even folks that have advanced dementia can talk about traumatic things that have happened to them. There's a really good article on that. I'd be happy to send to you if you want to shoot me an email after this session. but believing the person and what they are speaking, what they are saying to you is just critical, particularly when I think society dismisses us more and more as we age and doesn't take our opinions and our experiences seriously. You can provide caring and supportive messages in response to the client, even if you are at a loss about what services to offer in your community or what to connect them to. You can just show that you care and you are there to support them and, you know, sit with them. Ideally, you're going to have some informational materials and resources on abuse in later life in your community. We're going to talk, as I said, a lot more about resources in a future module. And then you can reassure them that they are not alone. Maybe by not acting shocked, like this is the first time you've heard it, but let them know they're not alone in experiencing this, and they're not going to be alone in having to deal with what they are dealing with. You can also refer them to your local domestic violence, sexual assault agency that provides advocacy, support, safety planning services. Ideally, you have somewhere in your city that does all that and is accustomed to serving older survivors. We're going to talk about that a little bit more too. And then aside from the DVSA organizations in your community, see if you can learn about other sources of support and safety in your community that might be appropriate. For example, if your client is in the LGBTQ plus community, are there organizations that just serve LGBTQ plus folks? If they are from a particular ethnic group, maybe there is a place in town that they would feel safe connecting with because that is their culture in their community. Can you help them identify some safe friends, safe family members that they can lean on? Those sorts of things. If you have other suggestions about what to do when somebody discloses abuse, feel free to drop those in the chat as well. Finally, I mentioned earlier the role that isolation plays in experiencing abuse in later life. Isolation is a huge risk factor for abuse. Related to that, studies have shown that having good, strong social supports can reduce the effect of abuse, particularly in terms of depression and anxiety and poor health. Similarly, when people have strong social supports and are connected to supportive communities and engaged with their community, their risk of abuse is going to go down. So just something else to keep in mind. I'm going to turn it back over to Jane.
Another component that is crucial to incorporate into your early communications with your client and throughout your relationship and communications with your client are explanations of privacy and confidentiality and what your obligations are to keep their information private and to not share what they tell you without their permission and informed consent. So this slide was also prepared by Alicia Aiken at the Confidentiality Institute. For a client, privacy means I get to decide who knows my information. Then the next step is you as the attorney or advocate working with a client, you're committing to protect the client's information. And that may be because of ethical rules or guidelines. Step 3 is privilege. These are statutes and guidelines and rules that protect the advocate or attorney from having to disclose the client's information. The attorney has a duty to inform the client of their rights so that they can make an informed decision about who knows their information and where it goes. Again, this slide clarifies distinctions between privacy, confidentiality, and privilege, and hopefully is helpful, will be helpful to you in explaining these concepts to clients. There is a chart in the materials folder that also summarizes state and territorial laws related to advocate confidentiality and privilege. So privacy, confidentiality, and privilege can be understood in this way. Individuals need privacy to exercise control over life situations. So much of an abusive relationship includes taking control away from a survivor. And in client-centered, trauma-informed representation, we should aim to empower our clients in whatever way we can, including giving them ownership over what information they share within our relationship as service provider and client. Professionals promise confidentiality to build working relationships. Again, we should from the beginning talk to clients about why we are asking the questions that we're asking and what we will do with the information that they share. And again, get the client's permission and informed consent to share it with others. And along the way, also educating and explaining to the client what their information will be used for. And governments bestow privilege to protect social values. Privacy is important, and professionals need to be able to protect the information that is shared with them, and that this will not be undermined arbitrarily. Of course, when the ABA is involved, we love to throw in the model rules whenever we can. I will drop the link to the full model rules into the chat. So these are rules and commentary on the ethical and professional responsibilities that lawyers are obligated to follow. These serve as a model for individual states to adapt and adopt. All 50 states and the District of Columbia have their own model rules that are based, at least in part, on these model rules. Every state varies in its own codification of the guidelines around lawyer-client confidentiality, so it is important to consult your own state's ethical guidelines for attorneys in order to clarify these requirements that we will be going over now. So ABA Model Rule 1.6a covers confidentiality, and it states, with limited exception, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B of Rule 1.6. So if you click on the link to the full model rules, you can look at 1.6b, which goes over some of the exceptions. For example, a lawyer may reveal information necessary to prevent reasonably certain death or substantial bodily harm. And that is a very high bar to meet in order to disclose information that should otherwise remain confidential. There are some other exceptions listed in 1.6b, and you'll also note that it says may share information instead of shall share information, meaning that an attorney has the option to share the information but is not required to. Another relevant model rule to our discussion today is Rule 1.14, client with diminished capacity. Again, this may not be adopted in its entirety in your state, so you should consult your jurisdiction's guidelines when you are working with a client who you suspect may have diminished capacity. Rule 1.4 states, when a client's capacity to make adequately considered decisions is diminished, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. This slide goes further into Rule 1.14. This is 1.14b, which requires that attorneys working with clients with diminished capacity engage in the following analysis. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken, and cannot adequately act in the client's own interest. If all three of those factors exist, then the lawyer may take reasonably protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. Model Rule 1.14C further states, when taking protective action pursuant to 1.14B, the lawyer is impliedly authorized under Rule 1.6A, which we went over a few slides earlier, to reveal information about the client, but only to the extent necessary, reasonably necessary, to protect the client's interests. That means that when you are revealing information about a client you are authorized to reveal information about, you can only do so in a very limited way, only to the extent necessary to protect the client and their interests. And I think this is related to a question that we got earlier in the chat, which asked, can a husband have sex with a wife who has advanced dementia? Would law enforcement have to be involved at this point? So I'm thinking about how you got that information, who has disclosed this to you. Is it your client? Because the client's seeking a legal remedy related to the sexual activity? Or is it someone who has power of attorney over the client, which is a topic that we'll be going over in the later modules. So I think at this point, you would be going through the analysis as to whether your client has diminished capacity. Do they not have diminished capacity? If they don't have diminished capacity, then it's their information to disclose or share, and you may be able to share it with their informed consent. If the client does have diminished capacity, then you would go through this analysis of whether the disclosure is mandated to protect the client from substantial physical harm. And if so, that doesn't automatically mean going to law enforcement. That means consulting with individuals or entities that have the ability to take action to protect the client. Again, not necessarily law enforcement. And in those cases, possibly seeking the appointment of guardian ad litem, conservator, or guardian, as it says in Rule 1.14. And did you have anything else to add to that?
Yeah, I think that I think you put it in really good context relative to the model rules, just kind of as a general principle when we're talking about people who have dementia. People who have the dementia have the ability to consent to sex, but the question then becomes, do they have the capacity to consent? So it's going to be a case-by-case determination. I don't think that we can give you like a blanket answer. But I think that for the attorney-client context, Jane gave a really good analysis about that. So if I hope that answers your question. All right, I'm going to pick it up, and we're going to talk about assessing capacity. I'm going to guess that if we have mostly civil attorneys and paralegals and legal advocates on this call, none of us is probably an expert on assessing capacity. It is a complicated process. It requires a lot of experience, and it shouldn't be attempted on an ad hoc basis. I know I don't have any business assessing someone's capacity, and I need to approach work with my clients by assuming that they are capable of guiding this interaction and that they have capacity until I have concerns that they do not. If you have concerns, you want to consult with outside professionals, if this is a concern that you're facing with your client. Recall the information too that we talked about in module 1 regarding common conceptions or misconceptions about capacity in older adults. So I think we all at all times need to check our own assumptions. But if you do have issues or think that there may be an issue, I would consult with a professional who does this does this for a living. It's important to remember that capacity is not the same as competence. Competence is a legal term, and capacity refers to our ability to operate in certain domains. So we can have the capacity to do one thing. I may have the capacity to manage my finances and do other things like that, but not, not other things. So capacity can be something that varies over time. It can fluctuate. And as I said, it varies from domain of functioning to other domains of functioning. So just a little word of caution there. If you do find that you need to consult an expert, if you're having questions about capacity, geriatric psychiatrists and psychologists are fantastic resources, as are geriatricians. Many hospitals and clinics have departments or whole floors or specialized clinics that work solely with older adults, and frequently have not just geriatricians, but geriatric psychiatrists on staff. You may also find social workers or family therapists who are expert in this area, geriatric nurse practitioners, and then don't forget about talking to somebody's primary care provider. If you, a lot of times older people, I know this was true, this is true with my parents, and it was with my grandparents, like they keep their doctors for a long, long time. If they find someone they like, they may be with them for many years. So if somebody will give consent for you to speak with their primary care provider, that person may be able to give you some insight into how their functioning has changed over time, if it has. And then there are some other professional guidelines on confidentiality that you probably should be familiar with. If they apply to you, there's the National Association of Social Workers Code of Ethics. There are APS guidelines, and those guidelines can vary state by state. But if you have questions about those, I would look at the National Adult Protective Services Association website, NAPSA. They are terrific. And then many states have laws that govern advocates, and you should be aware of those as well if that applies to you.
So many of the people participating on the call today are probably working for projects that are funded under the Violence Against Women Act, or VAWA, and there is a prohibition under VAWA from releasing confidential or personally identifying information without a victim's consent, with an exception of if the release is mandated by state, tribal, or territorial statute or a court. Grantees must therefore know their confidentiality and mandatory reporting obligations in their own jurisdiction. And it is not just VAWA that has this confidentiality provision, but victim services providers receiving federal funds through VOCA and FIPSA, which is a Family Violence Prevention and Services Act, should also be aware of confidentiality obligations that apply to them. I will mention here that the Confidentiality Institute has some great resources around confidentiality and the federal provisions. So I just dropped the link to a toolkit that's on the National Network to End Domestic Violence website into the chat. If you scroll down that page, you can find information about all of the federal laws, including VAWA, VOCA, and FIPSA. Comprehensive information about the statutory grant conditions for protecting victim confidentiality and privacy. And there's also some really useful sample policies and forms on that website. I'm trying to move to the next slide.
Want me to do it?
Okay, that would be great. Okay, so agencies working with older persons that receive funding from the Department of Health and Human Services under the Older Americans Act have an additional confidentiality obligation toward their clients. So under 45 CFR section 1321.51, confidentiality and disclosure of information, I will put that into the chat. that states that a state agency shall have procedures to protect the confidentiality of information about older persons collected in the conduct of its responsibilities. The procedures shall ensure that no information about an older person or obtained from an older person by a service provider or the state or area agencies is disclosed by the provider or agency in a form that identifies the person without the informed consent of the person or of his or her legal representative, unless the disclosure is required by court order or for program monitoring by authorized federal, state, or local monitoring agencies. It further states that a state agency is not required to disclose those types of information or documents that are exempt from disclosure by a federal agency under the Federal Freedom of Information Act. And finally, relevant to legal services providers under this law, it says a state or area agency on aging may not require a provider of legal assistance under this part to reveal any information that is protected by attorney-client privilege. So kind of to summarize these last few slides that we've been going over, there's all kinds of overlapping federal statutes based on the funding that your organization receives, along with the ethical rules that you need to follow in your jurisdiction. So all of these are important for you to have a grasp of so that you know what client information you are obligated to keep confidential and to help you and your agency develop an information sharing policy that takes all of these kind of puzzle pieces into account.
All right, we are now going to turn to the topic of mandatory reporting requirements for professionals who work with victims of elder abuse. In most states, mandatory reporting statutes govern an individual's responsibility to report certain injuries or cases of abuse and neglect to law enforcement, social services, or regulatory agencies. We included a copy of the Elder Abuse Reporting Laws Matrix in the resources for modules 1 and 2. And you can refer to that if you like, along with your state's mandatory reporting statute, if you happen to have one with you for reference, or if you can look it up. So we're going to be talking about that and how that impacts our work with the clients. There are some concerns, especially if you are a client, you may have some real concerns about mandatory reporting. You may be afraid that it's going to escalate the threat of violence, or that it will result in you actually becoming unsafe. You may be afraid that it's going to rob you of your autonomy, that the situation is going to be out of your hands, and that's really scary, right? Especially when somebody has been dealing with an abuser who's motivated by power and control. The idea that you may be thrust into a system that causes you to lose even more control is really, really scary. So it may very well deter victims from reporting abuse. Additionally, many of the people who are listed under mandatory reporting laws, and again, it varies from jurisdiction to jurisdiction, but a lot of those folks might not have any expertise in sexual assault, domestic violence, stalking, elder abuse. So they may not be making the report in a victim-centered way. And there are ways to do that if you are required to make a report. In some jurisdictions, for example, I'm in Wisconsin, and part of our statute states that you can opt, even if you are a mandated reporter, you can opt out of making a report if you have a good faith belief that doing so, that making a report would further put the victim at risk of harm. So unfortunately, that is not the case in many jurisdictions. If you're a mandated reporter and you find out about abuse, often it is just black and white that you have to report. But there are ways to do that in a way that is victim-centered. Another concern that folks might have with mandatory reporting is that there may not be resources available to help support that victim with the consequences of reporting that abuse. For example, they may be afraid that they're going to lose their housing. Maybe the person abusing them was also a caregiver and they're going to lose access to that. Maybe they are, going to be concerned about income. They're going to lose access to their income. Are there resources that are available to help them deal with those ramifications if a report has to be made? Some things to think about. So as I said, it varies by jurisdiction, who is required to make a report. In some jurisdictions, everybody who suspects abuse is required to report. In other jurisdictions, it is limited to specified professionals who are mandated reporters. And then still in other jurisdictions, there are some professionals like domestic violence or sexual violence advocates who are expressly exempt from mandatory reporting laws. So you want to find out before you enter into a situation where you think you have to make a report or where you find out that abuse is happening, you should really, really educate yourself on what your mandatory reporting obligations are and how you deal with that. Let's see. So many jurisdictions encourage individuals rather than requiring them to report. Just something else to look for when you look at your statutes. And I'd be curious to know, maybe drop in the chat if you know what your obligation is and what it is. If you know if you're a mandatory reporter, if you know that your jurisdiction has an opt-out clause in the statute, I'd just be curious to know how familiar you guys are with your mandatory reporting statutes. I'm going to keep an eye on the chat. And Jane has dropped the link to the state-by-state reporting chart. So thank you for letting us know you guys are mandatory reporters. If you don't know and you want to know, Jane dropped the link to the state-by-state reporting chart, which is really, really great to have handy. Even if you know what it is where you live, there may be a situation that comes up where you need to know what the obligation is for somebody in another state. So a good resource to have. And then just a reminder for VAWA funded service providers, if you work for a program that is funded by the Violence Against Women Act, you may not disclose a victim's confidential or personally identifying information if the statute says that your requirement is permissive rather than mandatory. So if your statute says you may report and not you must report, then if you're VAWA funded, you may not report. Does that make sense? I hope it does. If it doesn't make sense, drop a note in the chat. But basically, if you live in a jurisdiction where reporting is permissive, meaning you have the option, if you are funded by VAWA, you may not make a report. And then, again, just referring you back to that chart on mandatory reporting that is really, really good. Keep a copy of that at hand. Thank you for dropping that in the chat, Jane. I'm going to turn it back over to you.
I think now we have an opportunity to answer any questions that you have. So if you have any questions, please feel free to drop them into the chat now.
I think I'm thinking about things that like slides I want to add to this presentation. So I'm just going to talk through it right now while we wait for folks who might have questions. But there are ways to make a report in a victim-centered way. If you are a mandated reporter and you don't have an option, understanding all those hesitations and all those concerns that a victim might have if you're going to make a report, there are ways that you can work with them and partner with them to make it a little less traumatic on them. First of all, I think the most important thing is educating them about the process and letting them know what's going to happen. Now, if you don't know what's going to happen once you make a report in your state or in your jurisdiction, find out what happens when you actually make the report. Talk to somebody at APS. If it's law enforcement, talk to someone there. So you can tell the person for sure, like, this is what's going to happen when I make the report. Another thing that you can do is invite them to make the report with you. Don't make it seem like you're telling on them or something like that. It tends to, I think it makes it feel like more of a partnership, and it's more of a victim-centered approach if you have them sit with you and make the report and you are there supporting them and they're not just sitting around wondering what's going to happen. Another thing that is really critical is engaging in safety planning before you make that report. And making sure that their concerns, maybe their concerns are about housing or, going into a nursing home or getting care. Make sure that someone, if it's not you, that you can connect them with somebody who can help to address those concerns before the report is made. I think those are some important considerations. Jane, if you have anything to add, I just wanted to talk about that. Let me just see if there are any other questions in here. I don't think so. Should we just go on, Jane, and I'll keep an eye on the chat, or is it me? No, it's not me yet.
I think even though I have ability to control the slides, I don't
Oh,
actually have
sorry.
ability.
Sorry.
Thank you. So to recap, I will go over some teaching points from this module today. So the key teaching points include using a victim-centered approach to identifying potential abuse in later life clients and navigating challenges to client communication, including accessibility and cultural barriers. Privacy and confidentiality are critical components of victim-centered advocacy and lawyering. Be sure to know your obligations under your state's code of professional ethics and/or mandatory reporting statutes. So a little bit of homework for everyone to do if you haven't done this previously or you haven't looked at your code of ethics recently. And/or mandatory reporting statutes recently. We'll go to the next slide.
Sorry.
Also, victim-centered advocacy covers a variety of forms, both within and outside of the judicial system. So that's something else I'd like to emphasize is when preparing to set goals with your client, be mindful of the many different types of support your community can provide and that you can provide for abuse in later life clients. Again, some of those resources may not be legal resources, and the problems our clients need help with might be solvable by people that are not within the legal community. So it's our duty to create strong referral networks in advance of working with clients, so we know that they are safe and accessible to our clients before we make those referrals.
So for module 3, we're going to be back here 2 weeks from today at 1 o'clock Central Time on October 30th. And we're going to be talking about client goal setting and non-litigation responses. So what those topics include: figuring out with your client what their goal is of the representation, identifying some legal and community-based resources that can support your client, and then engaging in multidisciplinary collaboration and client advocacy. So basically, what are some things we are doing before we ever get into the courtroom to support our client and to facilitate our representation? This is my contact info and Jane's contact info. We really appreciate you guys being here today. We can hang on for a minute if you guys have questions. Otherwise, we hope we'll see you in 2 weeks for the next session. Thank you.